to fundamental rights. First, discuss the scope and significance of right to equality, which is enshrined in Article 14 to Article 18 under the Indian Constitution. Now, the scope and the significance of the right to equality under the Constitution. Right to equality is enshrined in Article 14 to 18 of the Indian Constitution, right? So, Article 14 to 18 is right to equality. It guarantees that all the citizens are equal before the law and prohibits discrimination on the grounds of race, religion, sex, caste, and place of birth. Or PS, right? Race, religion, caste, place of birth, and then we have the sex. So we have RCPS is for Article 14, right? So you have like 4 components. You have to imagine this as R square, and 4 words are present in the mnemonics. RCPS, race, religion, caste, sex, and place of birth. So race, religion, caste, sex, place of birth. PS is the keyword. SP or PS. You can keep whatever mnemonics you wish. Now, Article 14 ensures the equality before the law and equal protection of the law within the territory of India. So we have equality before law and equal protection of the law is only within the territory of the India. This means that no person or the group could be given special privileges and everyone should be treated equally by the law. We speak about the equal treatment over here. And Article 14 is equality is before the law. And then we have the equal protection of the law. Article 14 is equality before the law, and then we have the equal protection of the law within the territory of India. So this is within the territory of India. This means that no persons or the group should be given special privileges and everyone should be treated equally by the law. Article 15. It prohibits the discrimination by the state against any citizen on the ground of we have race, religion, caste, place of birth, and then the sex. Same for Article 15 and Article 14. It allows for the special provisions for the women and children. We have special provisions, and also for the advancement of socially and economically backward classes of the citizens, or for scheduled caste and the scheduled tribes. So we have special provisions, right? The special provisions is provided for women and children, right? Then advancement of the socially and educationally. Socially and education, right? So socially and educationally backward classes of the citizens and scheduled castes, scheduled tribes. So women and children, advancement of the socially and educationally backward classes of the citizens, SC and ST. So women and children, socially and educationally backward class of the citizens, SC, ST. Article 16, we have 1(6) right here, opportunity. Right. Equality of opportunity. Article 16 is equality of opportunity in the matters of public employment and prohibits the discrimination on the ground of religion, race, caste, descent, place of birth, residence, any of them. Now, Article 16 is having more, right? RCPES is coming or not? Let us check. Race is there, religion is there, caste is there, place of birth is there, and sex is also present. Now, in this place of birth only, we have descents, right? Descent, residence. These are the 2 things which are included, right? So we have the descent and then we have the residence, which are included over here. So race, religion, caste, sex, place of birth, descent. In the place of birth, you have descent as well as the residence. Okay. In the place of birth, you have descent as well as the residence. Now, Article 17 abolishes untouchability and forbids its practice in any form. Article 17 is related to untouchability. So, I can mention that Article 17 is related to untouchability. And it is going to forbid its form in any, forbids its practice in any form. The enforcement of any disability arising out of untouchability. Now, the disability, if there is a discrimination on the basis of untouchability, it is a punishable offense by law. Article 18 abolishes titles except the military and academic distinctions, thereby ensuring that no citizen is discriminated against based on the titles. So we have Article 18. Article 18 is abolition of the titles. So it abolishes the titles. Right. What kind of titles are allowed? Academic titles like doctor for DR and then we have engineer for ER. Academic titles are allowed and also military titles like captain are allowed over here. So academic titles and military titles are allowed over here. Academic and military titles are allowed. There is an exemption, thereby ensuring that no citizen is discriminated on the basis of titles. Significance is the right to equality. We have Article 16, Indira Swani case, right? Indira Swani case is related to Article 16 and it is 1992. Navtej Singh Johar is homosexuality, decriminalization of homosexuality in 2018. Right. Now, the right to equality is fundamental to ensure a just and fair society. It aims to eliminate inequalities that have historically existed in the society, Indian society, particularly those based on the caste, gender, religion. Supreme Court in cases like Indra Swani versus Union of India in 1992. So we have that Indra Swani versus Union of India in 1992, where upheld the reservation. This has upheld the reservation for OBCs are called as socially and educationally backward classes. We'll call them as socially and educationally backward classes. So we mentioned here, right? So it deals with Article 15, reservations. Public employment, right? Reservations in institutions, Article 15, reservations in public employment, Article 16. So, reservation for the OBCs, Navtej Singh Johar versus Union of India 2018. Navtej Singh Johar, right, versus Union of India. Here we say that there is a decriminalization of homosexuality, highlights the judiciary's role in enforcing and interpreting the right to equality, analyze the conflict between the right to freedom of speech and expression and reasonable restrictions imposed on her. Now we have Article 9(1)(a). The Indian Constitution guarantees the right to freedom of speech and expression. However, this right is not absolute. It is subjected to reasonable restrictions. For 1A, we have 19(2). Okay. Now for 1B, we have 19(3). Is the restriction. Now here they freedom of speech is Article 19(1)(a) is the freedom of speech and expression, right? So we need to discuss only on the freedom of speech and expression alone. So this right is not absolute and it is subjected to reasonable restrictions under interest of sovereignty and the integrity of India. First is India and security of the state, friendly relations with the foreign states, public order, decency, morality, or in relation to contempt of court, defamation, or incitement of an offense. So we say that public order, morality, decency, sovereignty of the state. Sovereignty and integrity also is included over here. Friendly relations with the foreign states, security of the state. And also you are going contempt of the court is included over here. In 1902 we have contempt of the court, but it is not defined in the constitution. Defamation is also not defined in the constitution. When sovereignty is not defined, I mean, we take references of sovereignty from the constitution. The security of the state, friendly relations with the foreign state, when public order is not defined in the constitution. Decency, morality is not defined in the constitution. And related to the contempt of court, defamation, and incitement to the offense. In relation to the, we say that there is a relation to contempt of court. Then we see we have the public order, incitement of offenses. Right. The conflict arises when the state imposes restrictions that are perceived to be as excessive or unjust. Thereby, it is lifting free speech. We have previous cases. Indira Swani is for reservations. Shreya Sinhal is for freedom of speech. The Supreme Court in the Shreya Sinhal versus Union of India 2015 struck down Section 66A of the IT Act, so which has altered the freedom of speech is Section 66A of the IT Act. Right. So Section 66A of the IT Act, which allowed arrest of the people for posting offensive online content on grounds that it violated the right to freedom of speech and expression. Balance between the free speech and restrictions is crucial in a democracy. The judiciary plays a key role in ensuring the restrictions are not used to curb legitimate dissent and that they adhere to the principles of reasonableness as laid down in various judgments. Now, we need to examine the role of the Supreme Court in expanding the scope of fundamental rights through judicial activism. Now, what is judicial activism? When judiciary is involved in making the rules or it is involved in making the law, it is what we call it as judicial activism. Judicial activism is proactive role in protecting the rights of citizens and ensuring the justice. Right. Supreme Court landmark cases through judicial activism. So we have fundamental rights, right? So we need to mention all the cases which are related to the fundamental rights. Judicial activism refers to proactive role by the judiciary in protecting the rights of the citizens and ensuring justice. So we say that the role played by the judiciary, first we have to protect the rights of the citizens and we have to ensure justice. Law is to ensure justice. The most important cases are, I mentioned 3 cases over here. Maneka Gandhi versus Union of India, 1978. It is 1978. This case expanded the interpretation of Article 21, right to life and personal liberty, to include the right to a fair procedure. We are bringing a fair procedure. The right to fair procedure. Maneka Gandhi versus Union of India, 1978. So we have Maneka Gandhi versus Union of India, which is 1973. Here, the interpretation of Article 21 is being expanded to include the right to fair procedure. Right. Right to fair procedure is being included. Vishaka versus the state of Rajasthan. In 1997 itself, the court laid guidelines, the court's guidelines. We mention them as the court's guidelines to protect women from sexual harassment. This is to protect from the sexual harassment. The court laid down guidelines to protect the woman from sexual harassment at the workplace. So we need to protect the women from sexual harassment from the workplace, expand the scope of Article 14 and Article 21. Right, Article 14 is equality. So Vishaka versus the state of Rajasthan in 1997 itself, the Supreme Court has laid out guidelines to protect the women against sexual harassment at workplace. Navtej Singh Johar versus Union of India is decriminalization. The court decriminalized consensual homosexual acts, thereby expanding the interpretation of Article 21 and 14. Thus, through these judgments, the Supreme Court has played a crucial role in addressing social issues, protecting individual rights, and ensuring justice. Judicial activism has been a pivotal in interpreting the Constitution dynamically and adapting it to the changing societal needs. Now, critically evaluate the right to privacy as a fundamental right in the context of Puttaswamy judgment, Article 21, 2017. The Supreme Court's decision in Justice K.S. Puttaswamy versus the Union of India 2017. So we'll be having the Justice Puttaswamy case versus the Union of India in 2017, right? It is a landmark judgment that recognizes the right to privacy as a fundamental right. So privacy is a fundamental right over here. The right to privacy as a fundamental right. Privacy is a fundamental right. Now, under Article 21 of the Indian Constitution, the court held that privacy is intrinsic to the right to life and personal liberty and is protected as a part of freedoms guaranteed by the Part 3 of the Constitution. Article 21, the judgment expanded the scope of Article 21 to include the right to privacy. Overruling earlier judgments, the judgment overruled previous Supreme Court decisions in MP Sharma versus Satish Chandra 1954 and Karak Singh versus State of Uttar Pradesh 1962, which had held that the right to privacy was not a fundamental right. Implications. The recognition of the right to privacy has significant implications for issues such as data protection, surveillance, and personal autonomy. It provides a constitutional basis for challenging laws and government actions that infringe on privacy. Puttaswamy judgment is a significant step in protecting the individual's liberties and ensuring that Constitution adapts to contemporary challenges. Explain the concept of reasonable restrictions under Article 19 of the Constitution. The concept of reasonable restrictions under Article 19 of the Constitution. Article 19.1 has guaranteed 6 fundamental rights to the Constitution: the right to freedom of speech and expression, assembly, association. Assemble. First, you have to assemble and then you have to join and form an association. Right. Assemble, association. So, freedom of speech and expression. Expression. Then we are going to assemble. Then we are going to associate with each other and we start to move. Right. Associate, and when we are moving, we need to reside at some place and we need to have certain profession also. Residence, profession. So, the freedom of speech and expression. Sorry, moment, I wrote something. Profession. The freedom of speech and expression. So, we'll be having the freedom of speech and expression. Assemble, association. So, the freedom of speech and expression, assemble, association. And then we have movement, residence, and profession. You have speech, expression, then you are assembling and you associate, then you start to move, and you find a residence and a profession as well. However, the rights are subject to reasonable restrictions under Article 19 to 21. Speech and expression, right? Speech and expression is very powerful. Therefore, it has more reasonable restrictions than compared to the remaining articles which are having reasonable restrictions. So, we have 6 reasonable restrictions, and these are mandatory to remember these 6 reasonable restrictions. Right? Article 19. 2 is for freedom of speech. You are speaking, right? Speech and expression. For the state, how does the freedom of speech should not affect for the state? To prevent the sovereignty, we have sovereignty of the state, right? And then the integrity of the state. Sovereignty and the integrity of the state. And we also have friendly relations. We have friendly relations with the foreign state. It must be protected, right? So friendly relation with the foreign state must be protected, and security of the state should be protected. So we have three things which is related to the state. The first is sovereignty and integrity of the state, friendly relations with the foreign states, and security of the state. The next thing is for the public order. And you have to behave decently in the public and morality. Public order, decency, and then we have the morality. And in relation to contempt of court. For the public, you have public order, right? And then you have to behave decently. So decency, and we have morality. Now, in public also, when you are speaking wrong against someone, there is defamation. And this might, when you are speaking wrong, that other person might incitement to an offense, attack you, slap you. So incitement to an offense. Incitement to an offense means we have two persons. Person A is advising or ordering person B to murder somebody or to commit a crime. So this is what we call it as incitement of an offense. Defamation and incitement of an offense is related to the public. And court has only one thing, and it is called as a contempt of court. Okay. Now, Article 19.3. This is related to the freedom to assemble. Now you are gathering at a place, you need to maintain the rules of the police, right? Police. When you are gathering, it is public place, right? So public order must be maintained. And sovereignty and integrity of the state must also be maintained. So when you are gathering, you are just gathering, you are not speaking. You are just gathering at a place. When you all are assembling, you need to follow the rules set by the police or set by the state. So public order must be maintained. You should not gather at a place and start beating everyone going traveling by you, right? Passing you. So public order must be maintained over here, and sovereignty and integrity of the state must be of the India must be maintained. Sovereignty and integrity. Right. Now this is 19.3. 19.4 is related to association. When you are forming an association, this association might also be a association like a terrorist association, right? So it is wrong. It is going to affect the morality of the society. You are forming an association of drinkers, alcohol addicts. You are forming an association. It is called as alcohol addicts. Addicts. This is a wrong association, so it affects the morality, right? Obviously, when you are gathering at a place and you need to form association, it affects public order and sovereignty and integrity. You give some value attached to the gathering. That is why morality comes over here. Now, 15 is residence. When you are residing at a place, what are the things you can do? Movement of residence can be restricted in interest of the general public. For public, your residence can be general public can be restricted. If a lot of people go and settle in only a particular area, it might cause environmental, economic, social problems over there. Right. So there needs to be a restrictions for the general public, for the interest of the general public, and for protect the interest of the scheduled tribes, ST. To protect the interest of the ST and general public and ST, your residence can be restricted. This is included for both freedom of movement as well as restriction. Right. Now, here the freedom of movement, and then you move and then you reside, right? So, both are having the same restrictions in 1905. They are not given as separate restrictions. Here, their movement is also restricted for the interest of general public and for the protection of the interest of the ST. So you can tell, right, I can move to ST. No, you should not move to STA protected area. You should also not reside in ST protected area. Now the final one is profession. How do you choose a profession? The freedom of profession, occupation, trade, or business can be restricted for the general public. That's all. Because when you are not a doctor, but you practice medicine without a doctor degree or without a professional course, it affects the general public. So, for the interest of general public, movement and residence also contains general public. Here also we have general public. In remaining cases, we have public order of the public, right? But in movement and residence, we have the general public, and as well as for the profession, we have the interest of the general public, not public order, right? So, public order belongs to the first freedom of speech and expression, the second association, assemble, and third association. Now, the fourth is movement and fifth is residence will have general public, as well as the sixth with this, which is profession, will also include the general public. Judicial interpretation. The Supreme Court has interpreted reasonable restrictions to mean restrictions that are not arbitrary, excessive, or disproportionate to the requirement or purpose sought to be achieved. In Chintaman Rao versus State of Madhya Pradesh 1950, the Supreme Court held that the phrase reasonable restrictions implies the limitations imposed should not be arbitrary or excessive nature beyond what is required in the interest of the public. Now, the next question is to discuss the relevance and implications of the right to constitutional remedies as the heart and the soul of the Constitution. So, the constitutional remedies is referred to as the heart and even the soul of the Constitution. Article 32 of the Indian Constitution provides the right to constitutional remedies, right, allowing the individuals to move to the Supreme Court for the enforcement of the fundamental rights. So, Article 32 of the Constitution is mentioned right to constitutional remedies. So, you are providing a constitutional remedy, and Dr. B.R. Ambedkar described Article 32 as the heart and soul of the Constitution because it provides mechanism for the protection and enforcement of fundamental rights. So, Article 32 of the Constitution, once again we are reading this, provides the right to constitutional remedies, allowing individuals can move to the Supreme Court for the enforcement of the fundamental rights. Dr. B.R. Ambedkar described this Article 32 as the heart and the soul of the Constitution because it provides a mechanism for the protection and enforcement of fundamental rights. Now, key features of writ jurisdiction. They issue writ. This writ jurisdiction, the Supreme Court and even the High Courts issue writ jurisdiction under Article 226. Now, we need to include the writs. Right. Writs are habeas corpus, mandamus, certiorari, quo warranto, and prohibition. Supreme Court of Fundamental Supremacy of Fundamental Rights. Article 32 ensures the supremacy of fundamental rights by providing direct access to the Supreme Court for enforcement. Judicial review. It empowers the judiciary to remove the constitutionality of the laws and executive actions, thus acting as check on the other branches of the government. The right to constitutional remedies is significant for the protection of the fundamental rights and upholding the rule of law. It ensures that the citizens have direct and effective remedy against violations of fundamental rights, thus reinforcing the principles of justice. So the courts are for the principle of justice and for equality.